in the middle of this, I have a problem, and I just leave. I don't tell you guys anything. And everybody just sitting around here like, what happened to the judge? What's going on? If someone had called me right now with an emergency, if my mom or somebody would call and say, it's an emergency, we need you back home, you know what I'm going to do? I'm going to say, everyone, excuse me for a moment. I'm going to get on the phone. I'm going to call the powers that be and say, I need a judge. I have to leave. I'm going to tell everybody here, everyone, I'm sorry. I need to leave. I need to get a flight. I need to work on that and go home. And just one moment, let me pull up what Ms. Abrams has sent me. Here we are. All right, the court is calling 2022 CR 0491. State of Texas versus Jeffrey A. Adames. Could I have parties announced for the record for the state?
Travis Banks for the state of Texas.
Defense.
Jay Moritz, Your Honor, from Mr. Adame.
And are you Mr. Adame?
Yes, ma'am.
Is your last name Adame or Adames?
Adames.
All right. I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Jeffrey A. Adames who was placed on community supervision for the offense of assault, family choking, strangulation on February 23rd, 2022 for a term of 5 years? Is that you?
Yes, ma'am.
State.
Violated condition number 28 on or about the first day of May 2023 in Bexar County, Texas. The defendant, Jeffrey A. Adames, did then and there fail to comply with the rules, regulations, or instructions of the Lifetime Recovery Substance Abuse Treatment Facility, and that the defendant prematurely departed the program without permission in violation of condition number 28.
All right. And Bashan, he's going on 28.
Yes, thank you.
To that, how do you plead? True or not true?
True.
State.
And the state would waive and abandon the further allegations.
All right. Did you understand by pleading true to violation of 28, the court could find it true, grant the motion, and sentence you up to 5 years in the prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of 28?
Yes, ma'am.
Counsel, any objections to the waivers of the other allegations in the motion?
No, Judge.
All right. Is there a recommendation?
Yes,
The recommendation and the agreement of the parties, should Your Honor choose to accept it, is to deny the motion and alter and amend the defendant's conditions for SATIF with aftercare, and have the defendant complete that drug treatment.
All right, is that the recommendation?
Yes, my understanding is that it was held in abeyance if he didn't comply, and that he is agreeable to it and wants that treatment, Judge.
All right, probation?
Yes, Your Honor. The recommendation would be for static with the aftercare, and if he does not want to do that, I recommend revocation.
All right, you'll raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand if you'll state your name for the record.
Jeffrey Allen Adames.
All right, why did you leave Lifetime Recovery?
My father was diagnosed with brain cancer. I had to help because I get disability retirement. So he was going to lose his house. So I decided to, my two brothers weren't working. So I decided to leave so I can use my disability retirement to help him out with his, till he had the surgery. And then when he went to recovery in University City, he started the recovery. My brothers got a job, so I was able to leave. And I was working on trying to get some money so I could turn myself in, which I did in the 13th of last month.
Yeah, why don't you pick up the phone and call probation and say, my father has cancer and I need to help him?
I freaked out. I mean, I was just, I was just real distressed. I mean,
No, how old are you?
I'm 50 years old.
No, it's easy to pick up the phone and say, my father has cancer. I need to go help them. And then if probation would have said, no, you can't do that, then you know what would have ended up happening? I would have got an email from probation and they would have sent it to me and said, his father is ill. He would like to go be with his father. And then you know what I would have said? Have him come in and we would have discussed it. And maybe I would have let you take care of issues with your father. You are on probation. Probation is a contract. So even though your attorney, the state and probation is saying SATA, I could still say I'm sending you to prison for 5 years.
I understand.
Do you understand?
Yes, ma'am.
So now what has happened? You're still in the same situation you are. Now you're starting all over. When lifetime recovery, you probably would have been finished with it by now. Now, instead, if I follow this agreement, you're going to be in custody and wait for transfer to SATA. All because you don't pick up the phone and call anybody. And lifetime recovery and all of these treatment programs are supposed to teach you how to deal with your problems. And dealing with your problems are not supposed to be, I'm not going to follow the rules. I'm going to throw my hands up. What if I had a problem and I said, in the middle of this, I have a problem and I just leave. I don't tell you guys anything. And everybody just sitting around here like, what happened to the judge? What's going on? If someone had called me right now with an emergency, if my mom or somebody would call and say, it's an emergency, we need you back home, you know what I'm going to do? I'm going to say, everyone, excuse me for a moment. I'm going to get on the phone. I'm going to call the powers that be and say, I need a judge. I have to leave. I'm going to tell everybody here, everyone, I'm sorry. I need to leave. I need to get a flight. I need to work on that and go home. I'm not just going to leave. And then everybody's like, what do we do now? And in your case, when you just drop off the face of the earth, you know what the what do we do now is? File a motion to revoke. All right, how much longer did he have in lifetime recovery? Will lifetime recovery accept him back or no?
Your Honor, that would be something I have to research.
All right, so this is what I'll do. If you want, I will sentence you to prison for 2 years, or I will send you to SATA. And if lifetime recovery will accept you back, then it'll be lifetime recovery if they accept him back. If they won't, he'll go to SATA.
At this point, I really don't think lifetime recovery would be the best option. I
Okay.
think we would need something a little more structured.
All right, so it will be SATA. So you can go to prison for 2 years, or either you can go to SATA. Which would you prefer?
Status, ma'am.
All right, I'll deny the motion. Alter and amend conditions.
Yeah.
To include SATA. Followed by aftercare. And I'm going to want the UA hotline upon release. And that's to be until further notice. Is there anything else you need from the court so that I won't see you back up here again with the motion to revoke? Probation, is there anything else he needs? All right, good luck to you.
At this moment, the judge knows something isn't right. The drug test is sabotaged and patience instantly runs out. With a cold stare, the court makes it clear dishonesty will not be tolerated. One bad decision turns into a life-changing consequence as prison suddenly becomes very real.
Which I find very suspicious. Yeah, no,
Number two really bad,
nobody does that.
and I was trying to take.
Court is calling 2023 CR 0889, State of Texas versus Stephen Wayne Walbarker. Could I have parties announced for the record for the state? Defense,
Ron Ross for defense.
are you Stephen Walbarker? You entered a plea on June 15th, guilty to count 2. According to the plea bargain agreement, punishments be assessed at 8 years in the prison. The state is silent on your application. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, we have, Judge, and by the way, it's a capital H.
Ah,
Yes, and state is silent, Judge.
all right, if y'all want to, oh yeah, it is a captivate, okay. And the state is silent. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
We have, judges, just one correction or
Yes.
in the TAP evaluation down about toward the end of it, said that he's continued to use marijuana since he was arrested, and he says that's not true. He said since he's arrested, he was using it before, but since that he hasn't used it. That's what he tells me.
Well, we can't get a UA because
I know.
he stuck his hand in the cup. Nobody does that. I don't know anybody who would purposely or accidentally stick their hand in a cup of urine.
I just, there was no urine, ma'am. I just grabbed the cup. I didn't even.
Yeah, nobody does that. You wasted a UA in this court.
I can,
So, counsel, anything you wish to say on behalf of your client?
Judge, I would say that he's 55, and I think his report, he's got child support obligations. He looks, I don't know that he's not diagnosed as mental slowness, but it seems to be. And his jobs, he's not had real good jobs right now. He works at a cook, but he is employed. He's been employed, and I don't know that this point in time, sentencing the prison is going to really make much difference or correct his behaviors. I would ask you to make him do outpatient treatment. Let's see if give him a chance. I mean, I agree with you. I think it's kind of ridiculous what he says, but give him
Oh,
outpatient.
I would tell you, counsel, outpatient treatment is going to be out of the question. He's going into custody today. So either he's going to prison or either he's going to treatment. Those are his choices. Either he's going to safety. I know they're recommending SADC, but for someone to purposely invalidate a test, that tells me a little bit where he is with regards to his sobriety. So either you have a choice. You can go to safety or you can go to prison. If you wish to go to prison, I will sentence you to 4 years. Which do you choose, prison or treatment?
I'll take treatment.
All right, the court will sentence you to 8 years in the prison. Thank you. Suspended and probated for 8 years. Take in consideration 2023 CR 0888. Thank you. Going to sentence you to Safe P, followed by aftercare. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be the UA hotline upon release. There's to be no unsupervised contact with minors. Regular reporting by Zoom or in person. Field visits 1 time per month for 4 months. And if everything is going well with the field visits, probation, I'm going to want random field visits after that, and you'll be able to pick how often you wish to do that. There's to be 200 hours of community service restitution. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
Judge, anything else?
Anything else you need from the court to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yeah, yes, ma'am. Oh, yes.
All right. You do have a right to appeal since there were issues raised through pretrial motions. But however, this is a felony conviction. You're not allowed to own or possess any weapons or ammunition, any body armor or anything of that nature. Do you understand? If you have a question over what a weapon or ammunition is or body armor, you'll need to speak to an attorney. Do you understand? We can go off the record. Mr. Walbarker, here's the thing. When I ask for people to do UAs, sometimes I know that people are going to come in and they're going to be positive. I can see the signs when people are going to be positive. The reason why I'm asking is because I'm trying to determine 1, your level of truthfulness, and 2, where you are in your sobriety. And when you are dishonest with me about your sobriety, you know what that tells me? That tells me you need to be in somebody's inpatient treatment. So you're going to inpatient treatment because of you. All you had to do was take the UA instead of sabotaging the UA test. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
You're welcome. I don't know if that's. Can I see the parties? Where did they go? It was David McLean. I guess they're looking into something. All right. Yeah, when you get a chance. Miguel Rangel. Okay. All right. So are you the attorney on all these cases or just one?
Just one, Your Honor, I believe.
Who is the attorney on the other cases?
I believe Mr. Castañon was appointed on this judge, on these cases. There seemed to be, sorry, Judge, something got a little convoluted with the jail when I made the bonds for Mr. Rangel.
Ah. All right, Mr. Rangel, you understand that he was the bondsman, not to be your attorney? All right, are you going to have any objection to his withdrawing?
No, Your Honor.
Okay. All right, thank you.
Thank you, Judge.
All
May I
right,
be
it's-
excused.
Yes, and Mr. Rangel, you're actually set to be back in court on August 15th. Okay. All right, you have any questions about anything of the process?
No, Your Honor.
All right, we'll have you brought back on August 15th.
Okay, thank
All right, thank you. Norma, can you make sure that the other attorney is on his case? That's 2023 CR 5021. So he'll make sure he has an attorney for that. So we're here for discovery. Where are we on discovery?
Judge, I think we're in good shape. We're just going to confer on an offer and would ask for another pretrial.
All right, so has an offer been tendered?
No, Your Honor.
Is that going to be tendered today? Or is that possible to have it tendered today or no?
It's possible.
All right, if it's not, just let me know. All right, so this is what we're going to do. Ms. Ferguson.
Yes, ma'am.
On Michaela Johnson, I need a 30-day reset. At that time, I'm going to need an acknowledgement of discovery and an offer to be tendered. And then after that, I'll give you a plea deadline date.
Thank you.
Judge, additionally, we
Oh,
have.
just 1 second.
Yeah, sure.
One thing at a time, then we'll take up the
No
other
worries.
thing.
Can do September 14th.
All
That's-
right.
That's good.
All right. So if you'll get the reset form ready for that, and let me just write this in the phone. All right. Then in two of the cause numbers, I have a motion to modify conditions of bond. Have
Yes,
both
Your
parties had a chance to review those?
I have, the state has and reviewed Mr. Hancock, and we're not opposed to it if that is verified. Mr. Hancock was sending me an email. I have not received it yet. It's verifying that she is enrolled in high school. And an alternative campus.
So Judge, I certainly can show Mr. Garahan, we do have verification. She is 17 years old, lives in the Northeast School District, Roosevelt High School. Through her mother and planning for her senior year, they have sent her to some alternatives campus for Roosevelt High School. So we're just seeking relief from the monitor so she can get up at, I think, attend at 7:45 a.m. and be home by 4 p.m. And Judge, if there's more cause numbers, I would like that to apply to all of them. You made a good point. I filed.
All right, you also have the cause number ending in 3850.
Would you add that, Your Honor, to one of the,
Yes.
thank you so much.
All right, we're going to go on the record. Court is calling 2023 CR 3848, 3849, and 3850, State of Texas versus Michaela Johnson. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Pat Hancock for Miss Johnson.
And are you Miss Johnson?
Yes, ma'am.
All right, the court is in receipt of motions to alter and amend conditions of bond. State, are you ready to proceed?
Yes, Your Honor.
All right, defense, you may proceed.
Judge, we filed the motion to amend the conditions of bond as Miss Johnson is on full house arrest GPS. Her mother is present today. And she's 17 years old and she attends Roosevelt High School through Northeast Independent School District. Her mother has been informed that due to these arrests, she would be sent to an alternative campus for the immediate future. And we are just asking permission for her to be able to attend school at 7:45 a.m. I think it's released at 4 p.m. So she'd be home thereafter.
All right, state, any objections?
No objections as long as the device remains in place and the curfew is enforced, Your Honor.
All right. So I'll grant the motions in each cause number, but she is allowed to attend school upon verification. So you need to provide verification to her pretrial services officer.
Done, Your Honor. Thank you.
So, Ms. Johnson,
Yes,
here are
ma'am.
the rules. These are your school hours. That does not include any activities that may or may not be happening. If you detour from your school to somewhere else, what's going to end up happening is I'm going to get a report. Your attorney is going to be called in here and you may end up being taken into custody. You understand?
Yes, ma'am.
All right. Any questions from anyone?
No, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Yes.
Yes, just real briefly, I had a chance to speak with Mr. Briseño.
Mhm.
Basically, we're in the same position as we were. They're not able to get it unless they've got a local court order. And everybody he's talked to nurses, he's talked to other investigators. Everybody's
Okay.
telling them they won't do it because there's supposedly some sort of liability issue.
All right. Norma? I'm going to need Jose Maria Cavazos bench warrant back here. All right.
I've got an address, if that'll help the court for the.
Oh, if you'll give it to Ms. Ferguson.
I can do that, Judge. Thank you.
And Norma, how long do you think it will take to bring him back from El Paso? All right, let's reset this for 30 days, but if he's back here sooner, just let the court know. What date, Ms. Ferguson? All right, so we'll be back on September 14th or maybe earlier. CR 3040, State of Texas versus Jeffrey Kesey. Could I have parties announced for the record for the state?
Thanks for State of Texas.
Defense?
Your Honor, T. Christopher Lewis on behalf of Jeffrey Peasley.
All right, the court is in possession of a motion to modify conditions of community supervision. Defense is asking that the no unsupervised contact be lifted. Is that correct?
That's correct, Your Honor.
All right, state, do you have any objections?
Yes, because of the nature of the charge. It's object.
All right, Mr. Kesey, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Who all lives in the home with you?
Now it's my children, my wife, and our former nanny.
All right, so why can't the former nanny, the wife supervise? Yes.
My former nanny is moving out
Okay,
and find her own place. And my kids got accepted to a science and technology school outside our district. And it's close 7 miles from my job. It's about 35 miles from my wife's job. So I'll just drop them off, pick them up from school.
Your Honor, I might add, during the sentencing process, you indicated that you did not want, at that time, his wife to supervise. You wanted the in-laws who were living with him to supervise and not just the wife. So that's why she couldn't do it.
all right, state, do you have any objection to the wife supervising?
If it is the wife supervising, no, the state has no objection to that, Your Honor.
All right, the wife can supervise, but the no unsupervised contact is to remain. All right,
Thank you, Judge.
all right, yes,
I do want to point out that Ms. Yes, it is.
okay.
That for CPS and
Thank you, probation.
Thank
All
you.
right, so this is what we're going to do. Because I know school is starting. I want to see how this goes with all of the confusion and miscommunications that sometimes happen when children are in school. So if you'll come back in November, because that will give you September and October to see how people are handling different issues, then the court will reconsider. But for now, the court will allow the wife to supervise.
Thank you, Judge.
And what did you learn from parenting classes?
I learned a lot. I learned different and better choice making when it comes to my children. And I've learned how to take time to react instead of being just immediate reacting from my frustration. And I learned just how to be a better and a more involved father.
And I'm sorry, what is your wife's name?
Shyla Kasi,
Spell that.
SHYLAH.
All right, is there anything else?
Nothing further, Your Honor.
All right, thank you so much.
Thank you.
Judge. That was a pleasure.
All right, who's here on Arthur Beecham? Yes. All right, so it appears that Mr. Beecham is not going to regain competency.
No, Your Honor, that's what the evaluation came back with. After that evaluation was done, Judge, the state, and by the state, I mean Miss Sally Ungerfer, requested that my client do a DID evaluation through ACOG. We had that evaluation on July 12th. The doctor has 30 days to turn it in. It's just shy of that. I confirmed with the clerks at the magistrate court that they still have not received the results of the DID evaluation. And until we get that back, the prosecutor that I'm conferring with will not kind of have an answer on how to resolve this case, Judge.
All right, so Mr. Beecham, usually this is the way it works when there are competency issues and persons are not regaining competency. According to the law, you will sort of be on probation for whatever the range of punishment is for your offense. So this offense is 20 years. So unless somebody decides to dismiss your case, that means we're going to be with each other for 20 years. Well, I probably won't be here for another 20 years because I'm in the twilight of my life, but somebody will be here. So this is what we will do. We will just do check-ins. So are you able to come down to the court every now and again?
Yes, ma'am.
All right. So what we'll do is we'll just set him for a check-in. What do you think is appropriate, counsel?
Judge, if whatever the court feels, if you would allow 60 days, Judge.
Okay. Is his mom here?
Yes, Judge.
All right. Could his mom come up, please? Hello. All right. So I know you work.
Yes, ma'am.
So are you able to Zoom?
Yes, ma'am.
And will you be able to Zoom with him?
Yes, ma'am.
All right. So let's do this. And I'm going to be dependent on you because I'm trying to do what's right to help him. And the state is trying to do what's right. And his counsel is trying to do what's right. So I'm going to schedule you all sort of like what they would do if you were in Judge Carruthers Court, which is the mental health court. It would be nice if I could transfer this file to them. So every 90 days, we're going to have a Zoom meeting. If you feel that he's off his meds or something's going wrong, let us know. Because what I can tell you is when people are off their meds, things quickly go downhill. And then the problem becomes a bigger problem than what it otherwise would have been. So we're going to set him every 90 days to check in, to make sure he's doing okay. And mom, if he's not doing okay, if you will let his attorney know, and attorney, if you'll let me know. And again, if he's off his meds, my intention, and I'm sure the state's intention, is to make sure he gets back on his meds and everything is okay.
Yes, ma'am.
So, Ms. Ferguson, on this case, can I have a 90-day reset? Oh, you guys will be here on my birthday by Zoom. Okay. People don't care about my birthday. They're just setting things on my birthday. That's okay. All right. Yeah, it's, you know, I walk in the land of the living and the land of the dead, since this is the Day of the Dead. All right, so we're going to come back on November 2nd, and you all are writing on the docket sheet that they can appear by Zoom. And council, just make sure that you get the Zoom link beforehand so they can have it.
Yes, Your Honor, and just so the court's aware, my client's on a shot for he's on an injection, so
Okay.
he's been consistent with meds
All
the
right.
entire time.
All right. And Mr. Beecham, is there anything you need from the court?
Well, I was asking if I could get off a monitor.
I tell you what, let's take that up in November, because I need a sort of track record to see how you're doing. But I'll still let you do things while you're on the monitor, okay?
This one.
All right, so let me just see where we are, and then we'll think about it, okay? All right, thank you so much. And look at him coming in here with the Notre Dame thing, not realizing I'm an LSU Tiger. All right, I'll see you all back on November 2nd by Zoom.
Yes, ma'am.
All right,
Thank you very
thank you, you're welcome. Let's see what page that's on. All right. Kevin Luna.
What should have been a simple probation hearing turns brutal. The judge questions every excuse, every delay, every bad choice. Her message is sharp and clear. Probation is a contract. Break it and prison is waiting. One phone call could have changed.
All right, so we're here for discovery, and the last time we were here was in June. DNA issues.
Yes, sir.
So where are we?
We are, I just thought, spoke to Mr. Powers. The buccal swab and everything was obtained on July 3rd and then sent to the lab by July 10th. I just reached out to the lab this week. It will probably take 3 to 4 weeks for that to come back, which I was happy to hear that it will come back pretty quickly. And then I think at that point, then all the discovery, it seems, would be attained. There's some other little hiccups in here that the court may or may not be aware. There might be a co-defendant that might be charged also. I spoke with Mr. Powers about that also. So plea negotiations probably beginning here in the next, this next setting.
All right, so
Possible.
I'm gonna give you all a reset for 60 days. And then if you want to come back before then, Mr. Powers, you can set it before then. If you have your information before then, you can come back before then. Because I know DNA evidence, sometimes it's a little iffy. The lab thinks something's going to be done at a certain time, then it's not. So I'll set you for 60 days. And then if your attorney gets information before then, and he wants to come back sooner, he can always set it. Okay?
Yes, ma'am.
All right, Ms. Ferguson, on this case, if I can have a 60-day reset, it's Luna. All right, so we'll be back on October 12th. Mr. Luna, do you have any questions?
No, Your Honor.
Okay. Yes, discovery. All right, if there's nothing else, you are excused. And everyone, we're taking our recess at exactly 12 because we have a jury coming back. Andrew Guerrero.
Good morning, Judge.
All right. And counsel, are you all ready to proceed?
Yes, Judge, we are.
Court is calling 2021 CR 6159, State of Texas versus Andrew David Guerrero. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Alfonso Cabañas for the defendant, Andrew Guerrero.
And are you Andrew David Guerrero?
Yes, ma'am.
I'm showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Andrew David Guerrero who's placed on community supervision in 2021 CR 6159 for the offense of evading arrest detention with a vehicle on November 19, 2021 for a term of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 4. In Bexar County, Texas, the defendant Andrew David Guerrero did then and there failed to report to the supervision officer as directed for the months of February and March 2022 in violation condition number 4.
How do you plead to that? True or not true?
True, ma'am. And Your Honor, we'll waive the remaining violated conditions.
Any objections to the waivers?
No objections, Judge.
All right, did you understand by pleading true to violation of condition number 4, court will find it true, the court could find it true, grant the motion, sentence you up to 3 years in the prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, there is, Your Honor. And the consent did not deny the motion, extend the individual for 6 months and amend conditions to add state ISS cognitive behavioral track. And also have the probationer be supervised by the gang unit. That is also the recommendation by probation.
All right, counsel.
That is the recommendation, Judge, in conferring with my client, he's asking the court to follow a recommendation by the probation office.
All right, General, raise your right hand for me.
Yes, ma'am.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Andrew David Guerrero.
All right, so why are you not reporting?
I mean, I have no excuse, but it was just around COVID and I was having hard times and that's it.
2022? That's COVID time? We were having court in 2022, were we not?
Yes.
And this plea was taken. Yeah, I don't understand.
I was just having a hard time and I'm just.
All right, so why are you people are always throwing COVID around?
Well, no, because I mean, I was looking for a job. I couldn't find a job. I was just having a hard time.
But what does that have to do about picking up the phone and calling probation?
Well, I had COVID at that time and I was reporting, but my probation officer had stopped me from going in and I was just calling and calling. And that's it. And I just stopped.
Here's the thing.
Just not.
You can't be before me and being dishonest, because I tell you what I will do. I'll have probation zoom in and let me know what's going on. I know COVID doesn't travel through the phone lines and they're saying you did not report. That's a problem. So basically what you're telling me is that you had COVID for the months of February and March.
No.
So why are you being dishonest with me?
I'm not. I just
making up reasons for not doing what you're supposed to do. Here's the thing. And this is what I've discovered in my time on the planet. When you do something wrong, you know what the best route is? Usually, I'm not going to get into legal discussions, but usually the best route is, I was wrong, I'm sorry. And guess what? When you say I was wrong, I'm sorry, the other person on the other end, if they don't accept your apology, then that's on them. But you've done all you can do. You can't go back in the past and mess with the time continuum and report. So why were you not reporting?
Just having a hard time, man. I'm sorry. I was just having a hard time.
All right.
I didn't have
And,
a place to stay. Didn't have a job. I was just having a hard time.
and what's with the drug issue? Do you have drug issues?
No, not at all.
Mhm. All right. Anything else from either side?
Not from defense, Your Honor.
I'll deny the motion. I'm gonna extend you for 6 months. State ISF, cognitive, and gang supervision. All previous conditions remain, and that means the no contact with Brianna Castillo. Is there anything else?
No, yeah, that's fine, but I don't see how she's coming up if that was what.
Because that's part of your conditions. No contact with Brianna Castillo.
Oh, okay. Well, yes, ma'am.
All right, is there anything else you need from the court to be successful?
No.
All right, and then probation upon release. I'm gonna want GPS and he's allowed to work. So it'll be partial for work. And that'll be until further notice. Is there anything else you need from the court?
No, ma'am, thank you.
All right, good luck to you.
Thank you, Judge.
You're welcome. Who's here on Austin? I'm sorry, Austin Anderson?